Number 15, matter of Eastbrooke Condominium versus Ainsworth. Counsel?
Good afternoon, Your Honors. Robert Jacobson for the appellant. I'd like to reserve 2 minutes of rebuttal time.
You may, sir.
This is a case involving a condominium tax assessment challenge, and it deals with several different parts of the real property tax law and the real property law.
And we get straight away to 339Y4, and isn't the statutory language clear there that we're talking about an individual assessment?
What the language basically says is that the Board of Managers can represent unit owners who want to be represented, and it doesn't say you have to do it over and over again every year. It just says if you want to be appointed, then you should be appointed, and there's no end to it.
I was referring to an assessment, the reference to an assessment. Can that be interpreted to be a single discrete assessment?
I think that would be nitpicking.
But that's what we're here for.
Well, I know, we're here for
It may be
nitpicking.
the only reason we exist.
An assessment, I think it can be, I don't think it's that narrow. If they wanted to make it discrete for every single year, they might have said that, and they don't have any deadline in there for doing it. In fact, I think it can be done.
Has that issue been brought up before, the distinction between the "and" assessment distinction?
The word "and"?
Has it been discussed in the lower courts?
I don't think anyone talked about just the word "and." They looked at the general language in the statute, and the argument was once someone's appointed the Board of Managers to be their agent, now we're into the agency rules and laws. And, you know, you have to look at this 339Y. It's part of the Condominium Act in the real property tax law. It's a condominium-friendly provision. It's intended to let them have special valuation rules. It's intended to let them band together in one single action. It was a remedial statute. It was something to benefit them, to say.
But by having a unit owner each year or for each assessment fill out an authorization, doesn't that make crystal clear that the unit owner wishes to be part of the action or the challenge?
I think that's just good lawyering, because I knew my opponent wasn't going to let me, rest on that. Having it filled out every year is good practice, but the plain language of the authorization itself said it was good for past, present, and future years. So it could go retroactive, it could go to the future. And by retroactive...
Sure, but are you suggesting that a counsel and a client could define the parameters of the statute if the statute means otherwise?
Well, the statute just says you need to appoint a Board of Managers to be your agent. Now, once they're your agent...
Through a written authorization.
Right, and the written authorization says it's good until revoked.
But that may be, but it doesn't say it's good for the past.
The authorization says it's good for the past, but here's the thing. If you appoint the Board of Managers to be your agent, now we get into the concept of agency provisions and the fact that, okay, I missed the first year or the second year, or maybe I missed a year in between. Can I ratify the agency? The thing is this, 339...
But the statute to me is clear about one thing, okay? And it's clear that you have to have a written authorization.
Right.
And to me, it seems like there are multiple purposes of that, but one may be to make it clear to the assessors what is being grieved or challenged. And so if I don't see how you can have the Board of Assessment Review having to figure out, if it doesn't say that it's for the future, or if it doesn't say it's for, whatever period of time, how are they going to figure out? And that's one problem. And the other problem is that the Board of Managers doesn't have any authority at all unless there is a written authorization.
Well, they have authority to bring the action if they have one unit owner.
They have one, that's right.
Doesn't mean that they're only acting on behalf of that one. If someone signs up late, can they get in with a ratification of the agency? And I don't see anything wrong with that. This is a taxpayer-friendly provision.
So a taxpayer can decide after they know what the outcome is to go back and say, okay, now I want in, now I'll share the expenses?
Well, I guess they could. First of all, there were no expenses in this case. The board paid them, which they had a right to do.
But we're looking
But
at this
okay,
for
looking at the
everybody.
big picture for everybody, I understand that. If they decide to get in later, can they get in backwards and forwards? I guess the question is, do you read 33Y, 339Y as a provision for the town board, a jurisdictional provision? It's not. It's a separate provision. If you take a look, even what the appellate division said, they go,
But it's referred to in Article 5.
it's referred to, but here's the thing. You look at the real property tax law, which has a lot of strict provisions for who can file a tax case. By the way, if I filed a tax case this year and I didn't fill out my authorization form, the case law would let me in. The case would let me in late. In other words, if a petition was filed, and in this case, our petition said it was on behalf of all Eastbrooke unit owners, there's even some of the appellate cases that say, if even you didn't have an oral permission to file, as long as you got it later on, it was okay. The cases that were cited in our brief, and on top of that, so they allow late authorizations under the real property tax law.
Up until when? How far does that extend?
Well, part of it has to do with when the town raises an objection, and in this case, there was no objection until the day of trial, or until right before trial. After a year.
Let's stay with the cases that you have an authorization for, and you have an initial authorization, then you have subsequent years, because we're going from what, 2008 to 2011?
Okay, I think.
All right. So that doesn't cover, there's 401 that it could, people or owners that it could potentially, condo owners that it could apply to, but let's assume it doesn't apply to all of them. Would it still apply to those people that you actually had the authorizations for once you have them, those authorizations going forward?
I think it should, because I'll tell you why.
Okay.
The tax law is flexible. They allow late authorizations, especially when the municipality doesn't object. And real property law.
I'm not talking about late authorizations. No, stay with me. I'm not
Okay.
talking about late authorizations. I'm talking about, there are some cases you got, some of the 401 you got authorizations for, and some you don't. Let's assume the ones you don't, they're out. All right? So the question is that in 2008, if I sign the authorization, is it good for all those 4 years, or is it only good for 2008? Do you have to sign one in 2008, 2009, 2010? You see what I'm saying?
It should be good for all the years, because
All right,
that's
why?
what it says. It's good for future years until revoked, and nobody revoked the authorization.
So in other words, your argument is that on that issue, not on whether it applies to everybody else, but
Right.
on that issue, what matters is the authorization, and this authorization complies with 339Y.
And 330
But if the statute said an authorization in each year, you're not arguing
If
that
it said-
that the lawyer and the client nevertheless could sign an authorization that they wanted to apply to future years as one document.
Perhaps, unless the case law under the real property tax law gave a waiver because the town never objected, but if they gave leniency, which the law
No,
regularly does.
just if the statute read
If it's
that you
specifically.
need one
right.
in every year.
I guess that might be questionable, but that's the big issue. In a tax case, when you
No,
have an.
it's a yes or no.
Well, if it said that, I think there still might be leniency,
Well, but
because that's what the real
Does the
property
statute
tax
say
law
that?
does. No, it doesn't say it.
If the legislature's saying you
The
need
legislator-
this, just take my hypothetical. Legislator expressly says you have to have an authorization for each assessment, each tax year.
I guess it would also have to say, and it can't be waived.
May I ask
Like
you
a
question?
statute of limitations, it can't be waived. And these cases are remedial, and ambiguities in tax assessment cases are supposed to be construed to the benefit
But
of the
what's
taxpayer.
the ambiguity in the use of the
Well,
singular, which is what the Chief Judge asked
I
you
guess
before?
you say an assessment. I mean, you can have an assessment every year. I guess if I sign up for 1 year, I'm in for all years unless I revoke it. I just don't think it's clear that the word "and" should be construed so
I mean, if it's
narrow.
the same assessment every year, once I've said I'm challenging that assessment, I shouldn't have to keep, or
No.
I'm authorizing, the board to challenge that assessment on my behalf. Is that what you
I
mean?
say to the board, challenge the case. I know these cases take years. Here, challenge the case. If I do it in year one, I should be allowed to just sit there and wait. I shouldn't have to do it every year.
Counsel, one last question
One
from
last
Judge
question, and this is,
Garcia.
just to step back for a second, as I understand, as a very basic understanding, you challenge the overall assessment of the building.
Correct.
Right? And here, whatever, approximately $3 million is knocked off the value, then they reallocate that to the condominium.
Correct.
So in signing on to a challenge, the condominium owners are challenging that overall assessment, right?
Correct.
What if they're challenging the allocation underneath? How do you do that?
That's what we do at trial. We do that at trial.
Isn't there essentially conflict in some way there? Like, so let's say you knock off $3 million from the overall value, and now you're going to allocate that new $19 million value. How do you do that? I mean, if somebody comes in and says, my condominium's worth X, but no, the person, isn't it just zero-sum game at that point?
If you remember, it's not about what my condominium's worth. It's worth it's what the entire project is worth as if it were an apartment project. Then it gets allocated in a logical way. Both parties present appraisal testimony. It might be based on square footage or whatever. It might be based on unit type and unit style. It's something that has to be litigated in the case, and that's how it's
But then do
determined.
all the people that have signed up with you have to agree on the way you're allocating it, your proposal?
They give the Board of Managers discretion to handle the case, and the Board of Managers has me handle the case, and the experts determine that.
And just forgive me this basic question again, but if you have condominium owners then who are not in your class, let's call it just for now,
Okay.
in your group, what happens to those apartments, the assessments on them? And
In this case, they don't get paid anything. They won't get refunds at all. They won't save any
Yeah,
of the
but what
money.
if they filed individually?
You're not allowed to.
Oh, they're not
not
allowed.
allowed to.
under the
So
statute.
the plan gets approved, and let's say that apartment, it would have been reduced $1,000, the tax.
Okay.
They don't get that
They
$1,000,
won't get their money.
but it doesn't affect then, the fact they're not in doesn't affect what anyone else who's in
No,
gets.
because the court case determines the value. We got a $4 million reduction. It was allocated equitably among all the units, and that's where we stand.
Thank
Thank
you,
you, Chief.
counsel. Counsel?
May it please the court, Thomas Fink, representing the town of Brighton.
Sir, aside from some possible ambiguity in the word "an assessment," is there anywhere else in the statute, in the whole statutory scheme, that refers to the form of the authorization, what it must contain, or whether it can be 1 year or multiple years?
The authorization that a condominium owner has to sign, authorizing the board, is exactly the same type of authorization that a townhouse owner has to sign, authorizing his attorney to file agreements. It's the same authorization that a business owner has to sign, authorizing his attorney to sign.
But where does it say that it's limited to 1 year at a time? I mean, the way I understand these work is that they take a while. And so they file for year one, and then when year two comes along and the case is still pending, they supplement that with a petition for year two, or whatever the case may be. Where does it say anywhere that you have to file a separate authorization for each one of those tax years?
In your case, 1938, Hilton versus Fahrenheit, where the question came up when there was a decision on some property, and the next year, this was before there was a freezing of cases under 727, the case was tried, and there was a higher value. And the petitioner came and said, well, you can't do that. It's raised, the first year is res judicata to the second year. It's the same property, and it's the same owner. This court said, no, each tax year is a separate tax year. And
Well, there's no
it's-
question about that, but here we have an authorization that says, I authorize you to do this for me in this tax year and the next one and the next one until I revoke that authorization. That's a different question.
There is no authorization for that type of language to be effective, because
Well, but
each tax year
You're
is a
arguing, it seems to me that you're fundamentally, you're equating the requirement to file an assessment, which the Board of Managers have with the agencies, the right of agency to direct someone else to bring that challenge to an assessment to me. And they aren't the same thing. And Judge Stein's characterization of the authorization is exactly right. I mean, what it says is this authorization shall apply to all pending and future proceedings for tax assessment review. There's no limit on them. They're all the same.
It would be the same if a townhouse owner said, I authorize.
Well, but the legislative intent here quite clearly was to allow, when they enacted this law, was to allow condominium owners to be able to let the Board of Managers go ahead and do these things.
It doesn't say that the condominium owner doesn't have to do the same thing that every other
The Property Act doesn't need to say what the agency requirements need to be. It seems to me that they have to address the assessment of the property, but it seems to me that we're confused here about what applies. That's what I'm struggling with.
In 2013, in the record 285, the petitioner's attorney said to the 402 owners, each year you have to sign a separate authorization. It was acknowledged, and when we went to trial...
What would be the point of that, though? What would be the reason you would have to do that? What value does that add to anything other than you don't have to make payments to certain units that haven't signed up?
The legislature could certainly have done something like that, but that was not what
But if it's ambiguous and we're looking at, okay, it has this language and assessment, what would be the policy driving an assessment of a condominium where you're challenging the overall value and the town or the village knows that's what you're challenging, and really what this goes to is payments? Because all the proof and all the plans are going to be the same. So what's the difference?
Every year is a separate assessment. This is what this court said. Every year, a value changes.
Right. And every year there'll be a challenge, and every year you'll have to go through this process. But what's the difference to the government entity, the municipality, whether or not you have an authorization that says 2009 for the next 5 years, or you get one each year, 2009, 10, et
The
cetera?
question is, who is a participant in each year? And the participant in each year
No,
is
that's not the
those...
question for the Board of Managers, though. The Board of Managers is bringing the challenge that, why would the government care who the participants are, one way or the other? All they care about is the challenge that's being brought. The Board of Managers, you're right, has to bring that every year. I understand that point. I don't understand how the Board of Managers relates as a representative body back to their condo owners, why you would even care about that.
Think of the owners of the condominium. Each year, they got a notice and said, if you want to participate in this year, you have to sign the authorization. Every year...
But are you saying that if they got a notice that instead said, if you sign once, it'll be good until you revoke it, that would be okay?
I don't think that's consistent in the law, but in
Okay,
this
so
case...
it doesn't really turn on what they were told, it turns on something else. So instead of contrasting it to a townhouse, let me ask you this. Can we contrast it to a cooperative, to a residential co-op, right? My understanding is in a residential co-op, the co-op board can file without getting permission from any of the owners, right?
Judge Wilson, frankly, there are no co-ops in upstate New York, so I am not familiar with it.
Do you have any?
Is Westchester now part of
It's
upstate?
hard enough for me to understand what a condominium is, let alone a cooperative. The property owners have a right to decide if they want to continue. They may decide this litigation is going nowhere, I don't want to participate, I don't want to be responsible for the cost, because that's what the section says.
So if we take, hypothetically, let's say, the proposition that co-op owners who live in apartments that look very much like condominiums don't have to file anything, and the board every year on behalf of all of them files a protest, is there a public policy reason to differentiate the condo from the co-op, or because you're unfamiliar with co-ops, you can't answer that?
Actually, in condominiums, according to Section 5 in 330, In New York City, you don't have to have, the board has the authorization, if they get a resolution, to file without any authorizations in New York City. But in the rest of the state, you need an authorization, and the property owner has a right to decide each year whether he wants to continue. He may not want to take the responsibility for the expenses.
Can I just I'm trying to understand your interpretation of the provision that requires the written authorization. So it says, the owner's written authorization to seek administrative and judicial review of an assessment made in accordance with, et cetera, et cetera. So you read that to mean the owner has to provide a written authorization for one specific assessment. And
Correct.
each year, there is a different assessment, even if it's the exact same amount. Is that your position?
That's exactly correct, Your Honor, because
Okay.
every
So-
year...
So then I'm not understanding your point, or maybe it was his point, about the multiple years, because it's an authorization to challenge that assessment. It may take years to resolve that, but that's the assessment you're trying to challenge, correct?
If the authorization is for year 2008, that authorization is good for 2008, no matter how many years it takes
Well,
to
it's the
try
authorization
2008.
for the assessment. So you mean the assessment that's issued in 2008? Is that what you meant? Or did I misunderstand you?
The authorization could very well change in 2009, could
Yes.
very well change in 2010, and
Or
there...
it might stay the same, but your position is the provision in the statute is talking about an authorization that is tied to only 1 year's assessment.
That's exactly correct. Just the same, and again, maybe you don't like this, it's the same for the townhouse owner, it's the same for a business owner. Every year is a separate year, and you have said that in Hilton versus Fahrenheit, and you explained why, because every year, the assessor has to look at the fair market value of all the property in the town.
But that gets back to this problem with condominiums to me, because in some cases, we have school boards who come in here and their pitches, you have to grieve every year because we set aside reserves and we need to know specifically that year's been challenged. But here they're challenging the overall assessment of the condominium, and you know that every year they're doing that, and you know that it's going to be the same. It's going to be $4 million here, whether or not who's in that pool or not's in that pool. Are you saying that you look beyond that, and each year you look at how many condo owners are in the pool, and that somehow affects your financials?
The condominium owner gets a break because their condominium is not a valued fair market value. In these cases, they were worth $100,000. Their assessment was $50,000, and they were trying to get it down to $35,000. So,
Yeah, but I'm asking, though, what would be the point for you of having these filed each year rather than as some of my colleagues have been asking, something that covers 5 years? What's the difference to the municipality, whether they do that or not? How does it harm you that there isn't authorization for each year? And again, given the example of the school board, where they don't have notice, if you don't file every year in some of these cases and you think it's riding over, they need notice to set aside reserves. What difference does it make where they're challenging the overall assessment of the building and that challenge is the same? What difference does it make to the municipality whether or not they have 100% or whether or not they have, authorizations that say 1 year or 5 years?
doesn't make any difference to the municipality.
Right.
It's not the municipality that's the issue here. It's the law that says a property owner has to file an authorization before their case can be tried.
But if the law is somewhat ambiguous and we're looking for a reason that would be, what is the reason for it?
The board just determined that their assessment for the entire list of condominiums was correct, and they denied the application. The question is, who is a participant in the case? And the law says a participant in the case in each year is the person who signs an authorization.
Do you pay any more or less money in the overall refund, depending upon the number of people
Yes,
who
and that's why it
authorize?
was important to us to find out who were the participants. And
Well,
in fact,
it's not a pot of money that then gets divided up if there's 2 people or 3 people or 200 people.
and that's why
So that's...
That's why council-
That's why you're challenging.
That's why council put into the record The authorizations in 2008, as an exhibit, the authorizations in 2009, the authorization is 2010, and the authorizations in 2011. He put in...
Why can't he put in an authorization that says, here's Mr. Jones, okay? Mr. Jones says let's say Mr. Jones didn't come on in 2009. Mr. Jones didn't come in until 2010. And Mr. Jones says, okay, from 2010 until I revoke this authorization, you may represent me, and I'm on board. I authorize you as my agent for every single individual tax year until I revoke it. What is the problem with the municipality looking at Mr. Jones's authorization and saying, okay, well then he's authorized for this year?
The same reason why the townhouse owner can't do it, the same reason why the business owner can't, because every year is a different year, and the property owner has to make a decision in every year whether he wants to participate.
What the townhouse owner is doing is filing a petition in every year, and that's exactly what the Board of Managers is doing. So that's where that analogy comes in. It doesn't have, the townhouse person doesn't have to file an
That's correct.
authorization.
And
Well, I thought your point is that potentially there's a different assessment in every year.
that's correct. Every year, there's a different assessment.
And the owner has to agree for the board to represent them with
That's
respect to
exactly
that
correct.
assessment.
That's exactly correct. That's our position. We think it's correct. The appellate division thought it was correct, and the trial court thought it correct. And all I can hope is that you think it's correct as well. And I thank you very much.
Thank you, sir. Counsel? Counsel, the Board of Managers, they have to authorize counsel to represent them each year, year after year. They have to renew that authorization, correct?
Yes, and they did.
So how does that impact our analysis as to the condo owner? So,
The condo authorization is completely different than the tax assessment petition authorization. The real property law says, is what creates the condo authorization. It also gives the special tax break for condos. If you look in the real property tax law, there's a provision in the tax law that talks about the special way of calculating the value for condos, but it doesn't say anything about authorization. That's because it was intended from the beginning that the authorization to appoint a board as an agent is completely different than the appointment of the Board of Managers as the agent to challenge assessments, to file the petition every year.
So
They're
is it
completely different authorizations.
So is it the board then that's making that decision every year whether or not to challenge the assessment?
The board makes the
You're
decision.
authorizing essentially the board to make that decision in the future.
Right. Now, the New York City provision that was referred to by council, the subdivision number 5, that has nothing to do with condo authorizations. It has to do with an election that the statute says can be made by the Board of Managers to take a tax abatement, an exemption. If a condominium is still going to file a petition, they still have to rely on subdivision 4 and get an authorization or whatever, but that's not what 5 stands for. That has to do with your question about co-ops. The other thing is, I never told anybody that they must file an authorization every year. I recommended it. It's just good lawyering. I knew that Mr. Fink would bring me to the Court of Appeals. I didn't want to mess around. I said, look, I advise you to do it every year if I were you, but I think one is enough, and that's why the actual document says it's good for past, present, and future years. On the idea of waiver, Mr. Fink and the town,
Yes,
they do-
alternatively, you just could have given them an authorization every year, right?
Well, I could have, but then it's an extra work. And you know what? These people are in Florida. These people end up in nursing homes. I mean, this is a low-cost property.
what about that person who ends up in a nursing home and maybe isn't aware that you're filing year after year, and then year 5, the assessment comes, and they have to share the costs of a lawyer or an expert or someone?
They gave me authority until it was revoked. If they lose capacity, maybe they could make that argument. But as long as they sign up and they say, you're my attorney until it's revoked, I don't see any reason to change that.
Well, the question is whether or not the statute permits that.
Right. Now, the other thing-
Even if,
Okay.
for purposes of this appeal, one were
Right.
to say that that is how we could read these authorizations, that there's no doubt, that's clearly the intent, that's what you and the owners agreed to. The question is whether or not that's permissible under the statute. So I'm asking you what I asked him. Do you read that language, written authorization to seek administrative and judicial review of an assessment made in accordance, to mean the assessment that holds fast until it changes, or an assessment that may potentially change every year?
The assessment was the same every year. It didn't change.
Are you saying, so
But an
there's no
assessment-
work that the assessor
what?
did every year to confirm the assessment is the same?
Properties have an assessment, and it's there, they always have an assessment.
Correct.
It can change,
My
but
tax
it's
bill
still...
reminds me.
It's still an assessment.
No, I understand that.
I read it
I'm
to
sorry, I'm
say-
not being clear. My question is whether or not the statute is not expressly saying that written authorization to seek administrative and judicial review of an assessment, given that an assessment happens every year, even if the number, the amount doesn't change, that's his position. Maybe you want to argue something else. Doesn't that then resolve this for us, that this means one assessment in 1 year?
I say, you have an assessment when your house is built, and you always have an assessment. So you could interpret the word "and" as being the assessment. The assessment, that's what you can challenge. I think, at worst, it's ambiguous.
You think
in which-
that's the ambiguity?
No, I don't think it's ambiguous. I never actually thought of it that way. But if it was ambiguous, it should be construed in favor of the taxpayer. One last point on waiver. They waited 5 years to raise the issue. They knew from the beginning that my authorization said it's good for all years, but they sat on it, and they waited 5 years till trial, which is the Skewes case and the Ernstrom case. If the town waited, we shouldn't get sandbagged after spending $15,000 for an appraisal, only to find out on the courthouse steps that we're out of luck. So even if you interpret the law the way you say that it could be interpreted, and means a new one every year, there's clear waiver here. And the waiver rules for tax cases are very liberal, and they're all mentioned in the brief. So I think that even if you want a strict interpretation, you should consider waiver in this case. That's what the record shows. They didn't do anything for 5 years.
Thank you, counsel.